You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his fantastic daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Welcome, Bill.
Good day.
Really excited about today's show. We have a lot of interesting stuff to go over. We're going to start off with the Department of Justice refusing to approve the merger between American Airlines and US Airways. Naturally, this is the top story for us. Bill, do you figure that this move by DOJ is just going to kill the deal right from the start? Or is American Airlines and US Airways, are they going to go and fight this in court in Washington?
Why don't we leave that conclusion for the end? And let's start by saying that the DOJ lawsuit was one of those exciting days in the newsroom.
Haven't seen something like that in quite some time.
It was wonderful. Bloomberg broke the story that the complaint was going to be filed a few minutes before it was. And I was sitting there watching the AMR stock collapse in price. Here's how that stock traded. Last fall, you could have bought AMR stock for 40 cents a share. Before the merger was announced in February, the stock rose to $1.30 because a lot of very smart people figured that no matter what, AMR was solvent, so shareholders would get something. After the merger was announced, the stock proceeded to rise as high as, get this, Lee, $6.80. The stock trailed off after that, fell a good deal lower by May, but nonetheless was still trading about $6 a share, a little under, when the DOJ hit the fan. The stock was like it fell off a cliff during yesterday's trading. It lost 45% of its value, and the last time I looked today, the stock was down another 15%. In round numbers, the stock went from 6 to less than 3. What intrigues me, Lee, is the question of what will AMR be like without the merger?
The worst case scenario.
That's right. The government takes the position that it's a strong airline no matter what. The interesting thing about, or an interesting aspect of the government's complaint is it isn't simply chock full of the government's own idiosyncratic economic analysis of the airline industry. Instead, what they did in very large part was to quote emails and speeches and whatnot from senior executives of the airlines, especially US Air. And basically what a lot of that comes down to, if I may be permitted to summarize, is that a lot of these executives said that over the last 2 or 3 years, they have been able to raise prices because of lessening competition and consolidation in the industry. So in other words, if they go to trial, the government is going to be proving this case out of the mouths of the airline executives, which I think increases the chances that the government wins. Also, by the way, this was a short complaint. You would expect that some blockbuster like this would be 200 pages long. And frankly, if it takes you 200 pages, you probably aren't going to win. But if you're like the government and they wrote their complaint in 34 pages, that usually suggests that you're more bullish about your lawsuit. In any event, Lee, AMR is in a very enviable position right now. They already have significant concessions from all of their unionized workers, and they are at least competitive, if not better off, than their major network airline competitors. They also, by the way, have the biggest single aircraft order, that is for new aircraft, in the history of the world. These aircraft will be delivered over the next several years, and when they are, this gives AMR several advantages, not the least of which is that new aircraft simply don't have much in the way of maintenance for a while, so that will allow them to drop more money to the bottom line. The new aircraft will also give them the ability to expand into different markets and chip away at the market share of their competitors. In addition, they have the flexibility to shift flying from their own American Eagle feeder airline to other airlines where the costs could be less. So you put all these things together, and it seems to me that AMR is in not such half bad a position, even if they can't merge. On the other hand, you can make an argument that actually it's US Air that needs this merger more than anybody else. Because remember, who was it that initially pursued the merger avidly? It was US Air.
Right.
Because they very well might, at the end of the day, if there's no merger, be the odd man out in the airline industry, facing competition from the big four airlines as well as from the little specialty, I shouldn't say little, the specialty but very competitive airlines at Southwest and JetBlue.
So, Bill, it sounds like you're saying that the equity in the AMR bankruptcy case doesn't necessarily get harmed if this merger falls through. Is that right?
No, I wouldn't go quite that far. I'm also persuaded that in the stock trading, all of the airlines' stocks declined. And what I'm reading into that is the market is saying that the combination would have lessened, the merger would have lessened competition and therefore allowed all of the airlines to do better. Call it oligopolistic pricing if you want to. But now if AMR is going to remain independent and indeed be a very strong competitor, then we very well may have intense competition everywhere so that airline shareholders, not only AMR but everybody else, don't do as well.
Let's take a look at the Rescap case, also known as Residential Capital, of course. They have a hearing on August 21st. That's one of two pivotal hearings in the company's plan to emerge from bankruptcy, aided, of course, by a $2.1 billion settlement payment from Rescap's parent, Ally Financial. Bill, will these hearings go down pretty much without a fuss, or is there going to be a hiccup here?
Oh, there's going to be a big fuss. I wouldn't call it a hiccup. Rescap is one of the most complicated cases ever to be in a bankruptcy court. The creditors are pretty much all on board except for junior secured note holders who are making an argument that they should be paid in full, only aren't being. So they're going to kick up a big fuss. But the bankruptcy judge has already indicated that he has a view of them as being obstructionist. I'm really tempted, Lee, to go to the hearing for approval of the disclosure statement because it could be a lot of fun to see what or how the judge treats the second lien note holders. But when all of that's done, I suspect this plan is going to go down. The only question is how big a rock is the judge going to drop on the junior lien holders.
Right. Let's touch on this Archdiocese of Milwaukee case. Last week, of course, we talked about the nasty fight where the Creditors Committee of the Archdiocese of Milwaukee is trying to have a district judge recused after he wrote an opinion unfavorable to the committee's sexual abuse victims. Bill, what's the latest here?
Interesting turn of events. The Creditors Committee, who represent the sexual abuse claimants, filed a formal motion to recuse District Judge Randa in Milwaukee. They say he has an actual financial interest in the Archdiocese cemeteries, which were the subject of the appeal where he wrote the opinion. Well, here's what the financial interest is. In the year 1975, that is to say 38 years ago, he bought a cemetery plot for his father. The committee argues that therefore he is an owner of property at the cemetery. He also has a claim against the cemeteries because part of the purchase price he paid was for perpetual care.
They're calling the judge a creditor.
That's
seen
right.
that before.
Because, I mean, Lee, what do you suppose a cemetery plot cost 38 years ago?
I have no idea.
A few $100s, not much. In any event, I won't necessarily call this a slim reed on which to hang your hat. But nonetheless, this is one of their major arguments. The other is that his mother and father are buried in these cemeteries who might be threatened with less perpetual care if the $55 million at issue here is taken away from the cemeteries. What it comes down to, Lee, is I don't see the reason for the fuss. The funds of the Archdiocese are not unlimited. Why waste time with recusing the district judge when you can go right now to the circuit court on the very important question of whether federal law prohibits the abuse claimants for getting their hands on the money in this trust for the cemeteries? Because if you don't go to the circuit court now, even if you succeed in having the judge vacate his own opinion, then you go back to another district judge for another ruling, and then eventually whoever loses is going to go to the circuit court. So let's just get this over with.
That cost the estate a lot of money to do all this.
It's teed up. Let's go to the circuit court right now and get this over with so we can get money into the pockets of the sexual abuse claimants. That ought to be everybody's first importance.
Let's close out with the Judge of the Week. This time it's Circuit Judge Carolyn King from the Fifth Circuit Court of Appeals in New Orleans. We talked about her before, Bill, because she's one of the leading experts on bankruptcy law among circuit court judges. She has a new opinion out. Can you tell us why it's important?
Well, it's important because it very materially extends the period of time in which somebody can sue a bankruptcy trustee or sue the bonding company that supplies a bond for the bankruptcy trustee. This is a case entitled Liberty Mutual versus La Mesa National Bank. It is a biggie in bankruptcy circles. If you're not a bankruptcy nerd, well, then you can tune off right now. In any event, here's what happened. A creditor sued the bonding company on a trustee's bond because the trustee had basically flubbed it in the case. The bonding company said, no, you can't sue because the statute of limitations under state law has already expired. Judge King said, nope, that's wrong. State law don't make a particle of difference in this context. She said that bankruptcy law alone tells you how long you have to sue a trustee or a bonding company for failure to carry out their duties. And what bankruptcy law tells you is you've got a period of years after the trustee is discharged before you have to bring the lawsuit. In other words, that is a very long statute of limitations which will run until after a bankruptcy case even has been closed. That's why I say, Lee, this is a very important opinion. Some people might think that it's not the right decision that she made. My guess is, however, probably most other courts are going to agree with it. But it's a biggie, as I said, Liberty Mutual versus La Mesa National Bank by Carolyn King on the Fifth Circuit.
All right, Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Lee Pacchia. Thanks for watching.